Now, the Muslim side says that the court today and the order today is not appropriate. We will approach the higher court. As expected, that the Muslim side is open to approach and get any kind of legal remedy. And in this case, there has to be an application made to a higher court of law, high court in this case. I'm going back to Vishnu Jain. Vishnu ji, talking about the key issue that we were talking, I want to draw a very important and critical distinction here. There are various Hindu religious structures in this country that were taken over during the Islamic rule and were converted into, say, mosque or other, places. It's a fact of history. You cannot deny it. There is a religious, the 1991 Act, which bars that you cannot convert the religious character of the place as it exists 1947. The only exception was Ram Janmabhoomi. When you argue about the Gyanvapi Mosque complex and you say that the dome has many structures which are Hindu in nature, you also have to very carefully frame your argument on those aspects of the Hindu nature which were operational. For example, the worship of Ma Shringar Gauri or the access of the devotees. Do you think this is a far-fetched argument to say that the entire complex is a Hindu structure? Is the court going to entertain?
No.
And if yes, what is the evidence you have?
See, the point is that the settled Hindu legal principle has to be seen and gone into, because what are the factors on which religious character has to be determined, has to be established, and the factors are that who was, please mark these words which I am telling today, who was prior in time. If I am able to prove before the honorable court that I was prior in time, then definitely all those things and all those places and in the entire complex will be declared as a Hindu complex.
What do you mean? What do you mean by prior in time? What do you mean by prior in time?
Prior in time, that who was existing before demolition of the so-called temple. If before the demolition of the so-called temple, I was existing, my temple was existing, then it has to be restored, because the Hindu law says, as per Honorable Mr. Justice B.K. Mukherjee, as per Mr. P.V. Kane, who is a Bharat Ratna, that once a property belongs and dedicated to the temple, till the end of the time it remains temple's property. So
no,
far
but
as,
are you
so
going
far
before 1947 or we are taking the cutoff date of 1947?
No. As of now, I am within the framework of Places of Worship Act. So my argument is that before 15th August 1947, it was a temple, and that continuity remained post 15th August 1947. So it's not that just on 15th August 1947 it was a temple. From time immemorial, this was a temple, and that religious character existed as on 15th August 1947 till November 1993. And after
Vishnu Jain, the lawyer of the Hindu side, he continues to be with us. We've lost that line, but we'll get that back. But here's what you need to understand, viewers, that at the heart of it is the argument from the Hindu side, that the original character of this complex is a Hindu temple. And they are staying within the precincts. They are staying within the limits of the 1991 Act. They are saying, after 15th of August 1947, or as on 15th of August 1947, there were active prayers and the worship of Ma Shringar Gauri, which was happening in this entire complex, and that is why over the time by the Masjid committee the character has been diluted upon. I'm cutting across back to my colleague Pranshu and Ananya, who continue to be with us on the broadcast. Pranshu, first to you. An initial hurdle has been done away with. You exclusively got us that order copy. What does the order copy really say? Could you take us through the key pointers? And on the next day of hearing, the framing of issues is going to happen by the court, written submissions to be filed.
Yes, that's right. In fact, all sides are absolutely clear now. We have heard what Vishnu Jain has to say, what Harishankar Jain has to say, and they are clearly happy that the court has been convinced by their arguments, by their interpretation of what is barred and what is not barred by the Places of Worship Act of 1991. The court in its order says that, the basic prayer, the basic case which was before its disposal was that of Ma Shringar Gauri case, which is not about determining the exact nature of a particular religious place, but about the right to worship at a particular spot. And the court says that under the Act, the study which has been done, the Act of 1991 doesn't bar a suit which, talks about the right to worship at a particular spot. And therefore the court says that, this particular case is admissible. The hearing should continue on it. Muslim side's first reaction, we now have that first reaction, and they say...
Go ahead, Pranshu, please go ahead.
Yes, the Muslim side now clearly feels that, what the district judge court has done, that is not as per the law. It should not have been done. They are disappointed by the court's order today, and therefore they say that they would be approaching the higher court,
Okay.
most likely the high court in this case because it's a civil suit.
Yeah.
They also might like to approach the Supreme Court because, it
Yeah.
was because of Supreme Court's order that district judge in Varanasi started hearing this case.
Yes, the Supreme Court had given a timeline. They had given certain prohibitory orders.